the state Senate that kind of was the impetus for bringing this around again basically gave the reason for doing so as there being new SCOTUS judges sitting on the bench. So
Right.
they know that the dichotomy of SCOTUS has changed quite a bit, and they feel strongly that they are going to be able to have more success than they have in the past. I think that's definitely true. So, I want to point out something before we listen to this because, I'm going to basically be talking to you from a philosophical point of view. I don't have a legal degree; I have a philosophy degree, and so that's my sort of background. But I do think it's really important that in order for you to buy into Stewart's argumentation, you have to assume something, and the assumption is that a fetus, a zygote, an unborn human is the same as a woman. So he's arguing from a point of view that is entirely religious, in my opinion. You'll notice that the language that he uses is he refers to the fetus as a girl, her, she. So it's never in terms of anything other than this blob of cells, so to speak, has the same autonomy as a woman does. So we're already in a problem area, in my opinion. But let's listen to what he had to say.
Nowhere else does this court recognize a right to end a human life. Consider this case. The Mississippi law here prohibits abortions after 15 weeks. The law includes robust exceptions for a woman's life and health. It leaves months to obtain an abortion. Yet the courts below struck the law down. It didn't matter that the law applies when an unborn child is undeniably human, when risks to women surge, and when the common abortion procedure is brutal. The lower courts held that because the law prohibits abortions before viability, it is unconstitutional no matter what. Roe and Casey's core holding, according to those courts, is that the people can protect an unborn girl's life when she just barely can survive outside the womb, but not any earlier when she needs a little more help. That is the world under Roe and Casey. That is not the world the Constitution promises. The Constitution places its trust in the people. On hard issue after hard issue, the people make this country work. Abortion is a hard issue. It demands the best from all of us, not a judgment by just a few of us. When an issue affects everyone, and when the Constitution does not take sides on it, it belongs to the people. Roe and Casey have failed, but the people, if given the chance, will succeed. This court should overrule Roe and Casey and uphold the state's law. I welcome the court's questions.
One of the things he's saying here is that Roe v. Wade basically enshrines the right to end human life. So he's saying abortion is murder. That's basically what he's fundamentally saying, right? The only constitutional right that involves the taking of life. He said that as well. So obviously he's framing this from a certain point of view from jump that I think is highly problematic. It's not a scientific point of view. If you look at Casey and you look at Roe v. Wade, when they talk about fetal viability, what they're saying, this is the point where we can scientifically prove that a fetus can live outside of a woman's body. So, I would say in the past, the argument was we can't really get into the philosophical arguments of when life begins, at conception, at birth, whatever. These are philosophical arguments. They're not within the realm of the law to litigate. But we can look at something that is objectively sound science and say this is when a fetus is viable. Let's use that as a workable mark. So that's basically where these previous arguments were coming from. So Scott Stewart is basically introducing what I would call a religious argument into the conversation, which is very problematic for obvious reasons. But that's sort of where we're at in the country as far as, these right-wing extremists are concerned. I don't think that this is the tone that the majority of Americans take in regards to the subject, but it is the point of view that the state of Mississippi is taking when arguing this case. So they've gone to a very far extreme, in my opinion.
Right. And I want to be clear. I'm a dude. I don't want to fake that I understand women's bodies or the menstrual cycles or pregnancy cycles, because I don't. And it would really become real bad memes if I tried to fake it. But what I do know is if you go to any doctor, a good doctor, they will say every person is different. And from what I understand, that does apply for women.
Absolutely.
So some women, Tina, correct me if I'm wrong, can know they're pregnant fairly early on. Some women might not know.
Most don't.
Yeah,
most don't. Yeah,
past.
6 weeks is. Yeah, most women don't know they're 6 weeks pregnant when they're 6 weeks pregnant.
Right.
So, if you have commonly skipped periods in your life, like maybe, now and then, and you skip one, you're not on, you're generally not going to automatically assume that you're pregnant, especially if you're feeling fine. So no, I don't think it's for these folks saying that a woman should know by week 6 that they're pregnant. That's absolutely ludicrous. It's not in the realm of possibility. And I think the other part of the conversation that I think is really even more salient is these guys are willing to usurp the individual liberty of women, right? They're now putting the zygote and the fetus on the same grounds as a woman who is actually a living, breathing human being, right? They're saying they're questioning that there's some sort of tension here as to whose rights are to be, in command control. I mean, which is ridiculous to me. This is a lot of where the personhood argumentation comes, right?
If we could move on to Justice Sonia Sotomayor, really frankly dressing them down, and what she said initially in response to this.
What hasn't been at issue in the last 30 years is the line that Casey drew of viability. There has been some difference of opinion with respect to undue burden, but the right of a woman to choose, the right to control her own body, has been clearly set for since Casey and never challenged. You want us to reject that line of viability and adopt something different. 15 justices over 50 years have, or I should say 30 since Casey, have reaffirmed that basic viability line. 4 have said no, 2 of them members of this court, but 15 justices have said yes, of varying political backgrounds. Now, the sponsors of this bill, the House bill in Mississippi, said we're doing it because we have new justices. The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts? I don't see how it is possible. It's what Casey talked about when it talked about watershed decisions. Some of them, Brown versus Board of Education it mentioned, and this one, have such an entrenched set of expectations in our society that this is what the court decided, this is what we will follow, that we won't be able to survive if people believe that everything, including New York versus Sullivan, I could name any other set of rights, including the Second Amendment, by the way. There are many political people who believe the court erred in seeing this as a personal right as opposed to a militia right. If people actually believe that it's all political, how will we survive? How will the court survive?
What stood out to me about what she was saying is she was basically saying that the large preponderance of judges and legal experts have not, even conservative ones really, have erred on the side of not touching this, citing precedent. So she's basically saying this is a monumental decision. It's not just some normal decision that you might overturn, another court's thing. So could you kind of touch on, I think she was pointing out, you guys, I think it was her calm, respectful, diplomatic way of saying you guys are extremists trying to overturn something that's sacred and settled.
It's sacred and settled. I mean, so we have 50 years of precedence keeping Roe v. Wade in place, not just Casey, right? Casey is also the second decision that fundamentally tied the viability thing to this. And in fact, the Fifth Circuit that saw the case before it went to SCOTUS basically said that they were blocking the state law from going into effect because of the viability that was entrenched in precedents with these decisions, which is the right thing. But I think the more salient thing that Sotomayor is saying right here is that she is concerned that SCOTUS is in danger. The institution itself is in danger because of the way it's being politicized over not only this decision, but other recent decisions. She's concerned, and I think she's right on this, that we've now reached a junction where we have judges that have been appointed to the Supreme Court that, in my opinion, don't belong there. They're not qualified, that are politicizing decisions, and that the public is no longer going to trust their mandate. And that's a very dangerous place to be.